Hi, I'm Mike Papantonio, and this is America's Lawyer. Tonight, we'll take on Monsanto, which has been made billions off of the sale of Roundup weed killer. But studies over the years have linked their blockbuster herbicide to cancer. And now a flurry of lawsuits are working their way through the court system to hold Monsanto accountable for covering up the dangers of Roundup for decades. So tonight, we'll look at what independent studies, the EPA analysis, and what Monsanto's own court cases have to say about the dangers of glyphosate, a primary ingredient in Roundup. And later in the show, we'll speak with attorney Jeff Feiger, who represented Jack Kevorkian, about the state of doctor-assisted suicide in the United States. So don't go anywhere. America's Lawyer starts now.
This is a classic whistleblower case within the pharmaceuticals. Fraud. Is a comment by this company was what you're doing is wrong.
Environmental lawyers have begun filing lawsuits against Monsanto for cancer deaths related to their product Roundup. What these lawsuits are showing is an effort both on the part of Monsanto and the U.S. government to minimize the message about the dangers of Roundup in relationship to human cancer. The story begins as early as the 1980s when laboratory tests on glyphosate began to show cellular changes in laboratory animals that should have been considered early signs of a relationship to cancer. In fact, in 1985, the EPA, during a time when it was actually effective, a time when it actually worked on behalf of a safe environment, they determined that glyphosate, the primary ingredient of Roundup, needed to be classified as a Class C carcinogen, which meant that it clearly was suggestive of a relationship to cancer. But then, miraculously, 6 years later, the EPA suddenly changed that classification to something just the opposite, where they claimed that, no, they were wrong. And overnight, glyphosate, according to the EPA and Monsanto, the public has no worries, nothing to worry about here, just move on. All of the laboratory testing from the early 80s that the EPA used to classify glyphosate as a cancer agent suddenly becomes unavailable to the public, unavailable to doctors, and Monsanto argues that all that early testing falls under the protection of trade secrets, so it can't be shared with anyone. The next twist takes place. The World Health Organization issues a statement in 2015 maintaining that glyphosate in Monsanto Roundup, in their words, is probably a human carcinogen. As you might imagine, Monsanto called in its army of paid scientists and lobbyists and politicians needing contributions and governmental agencies more concerned with mega profits than human health. With government, corporate-controlled media, and the White House pulling every string to protect Monsanto, it appears that the only place this story is going to be fully told is in courtrooms in front of juries. One of the lawyers handling the Monsanto Roundup case is an attorney called Robin Greenwald. You've heard that name because she's one of the finest environmental attorneys in the country. Robin, thanks for coming to the show.
Hi, Mike. Thank you for having me.
In the lawsuits that you've brought, Robin, have you made part of your claim that Roundup, it's primarily made up of glyphosate, they failed to warn users about the connection between that and cancer in this product? Do they provide a warning about that that the World Health Organization said should be provided?
No, Mike, there's no warning about an association between using Roundup and cancer. And our focus in our lawsuits is about non-Hodgkin's lymphoma. So it's the use of Roundup and the outcome of non-Hodgkin's lymphoma by some users.
Robin, give us a rundown on what you've alleged in your lawsuits against Monsanto in regard to Roundup. What the history, the knowledge, the possibility of them to fix this problem. Tell us what your lawsuit's about.
Sure. So the saga, as you mentioned at the beginning, started really when Roundup was being registered through the EPA FIFRA program, the registration process. And companies at that time have to give certain data to the government to show that their product is either safe or that it's not safe and needs certain protections. And so that's part of the registration process. And it's public record that 2 of the laboratories that Monsanto used to supply information to the federal EPA, both provided false data. And both of those laboratories, one was IBT in the 1980s, and then Craven Laboratories in the 1990s. They both were investigated, prosecuted, and convicted by the Department of Justice for providing false data in connection with Roundup and other chemicals, for that matter. So there's a sort of sordid past in some respects, and all of this is outlined in the complaint. And as you mentioned in your lead-up, the EPA originally classified Roundup as a glyphosate, I should say, as a Class C, and then it changed the registration to E, which is non-carcinogen. But it's important to note that when EPA did that... I'm sorry.
Yeah, that's what I want to ask you about. What changed, Robin? I mean, how do you go overnight? One day, yeah, we think it can cause cancer. The next day, don't worry about it, public. Don't worry about it, doctors. There's no problem here. How did that happen in your estimation as you've looked at this material?
Well, I mean, we're still uncovering a lot of that information now. But even when EPA changed the classification from C to E, it said specifically, our finding, our change from C to E does not mean that that glyphosate is a non-carcinogen. And so I believe that the government looked at different data, other data, new data. You know, unfortunately, these things happen when registration occurs and there's a certain classification. Companies that are registering products can give new information to the government. Different people look at different information. I mean, and unfortunately, from time to time, it is a moving set of facts. And certainly here, something happened within the process to change it.
Robin, what I find very interesting, and we've seen this, look, you handle some of the biggest, most important environmental cases in this country. I get that. And I know you see corporations gaming the system. But in this situation, all the early testing that was done, we now have Monsanto saying, no, you can't see that because it's a trade secret. It might be bad, but you can't see it. It might show cancer, but you can't see it. It might be threatening public health, but you can't see it. What's your thought on that?
Well, I mean, I don't agree with that. I think that any data, any scientific research that's submitted to EPA should be available to the public, but it's not. I mean, we all know that the law, our system, our regulatory system allows companies to submit scientific data to the government under what's called CBI, confidential business information, and when it has that stamp, the government does not give it to the public at large. You know, query why Monsanto doesn't want to share those studies with the public. If Roundup and glyphosate are so safe, then those documents and those studies should be documents that they would want to share with the public. But unfortunately, that's not what's happened here. And as we know, there's documents that are stamped confidential that the public doesn't get to see.
Robin, how extensively has Roundup been used throughout the world, and what is your concern, if any, about how it's affected our food supply? I mean, if we've got this used pole to pole, and all of a sudden we find out it does cause cancer, how does it affect the food supply? Is that something that you're going to be talking about in your trial?
So Roundup is the #1 used herbicide in the world, glyphosate. So Monsanto had a patent on Roundup until 2000. And then what it did in 2000 is it developed something called Roundup Ready seeds because it was losing the patent in the United States. And all of this is alleged in our complaint. So in 2000, recognizing they were going to lose the patent, they developed this Roundup Ready seed so that farmers who use Roundup Ready seeds, when they lost the patent, they would still have to use Monsanto's Roundup because that was the only herbicide that would be effective on those genetically modified seeds. So it is the world's most used herbicide, and I believe it remains that today. But we're not, our lawsuit, Mike, is focused on exposure to Roundup through application. So maybe the food case will come next, but right now our focus is on people who use Roundup in the application process. So those would be landscapers, farm workers, farmers, individuals who use it for home use, and it's really dermal exposure and inhalation in the process of exposure. And that's the focus in large measure of the World Health Organization as well.
Robin, are you seeing a large number of cases right now as you're screening these cases, as they're calling you, they would call you because you really are one of the foremost experts on this in the country right now. As they call you, are you seeing numbers increase?
You know, there has been there are definitely increasing numbers. I mean, I think as people learn about it, for so many decades, Roundup was used and nobody thought anything about it. People believed the label that it was safe. So now people are, I mean, so often we'll get a call from someone and say, you know, I used it for 15, 20 years and I never thought anything about it, and I was reading an article or I was on Google and I saw that it can cause non-Hodgkin's lymphoma, and I'm 40 years old. I have no history of cancer in my family, and I was diagnosed with stage 4 non-Hodgkin's lymphoma 2 years ago, and I'm still going through treatment. Do you think it's from Roundup? I mean, we get those calls often.
I see both Democratic and Republican senators, congressmen jumping behind to support Monsanto, even though they're seeing the same material that you're looking at. How has this become such a political issue, protecting Monsanto?
I mean, Monsanto is a huge corporation. It has a large swath of lobbyists and people who push hard to keep the product in the marketplace. And I mean, let's remember, it is a huge part of Monsanto's profit center. So it is something that they will fight hard to keep on the market.
Lawsuits have been filed nationally, Rob. Go ahead. No, go ahead, please.
No, I was going to say something interesting that sort of a little hidden fact in the complaint is in 1996, the New York Attorney General's office actually sued Monsanto over Roundup, finding their advertising to be false and deceptive in the state of New York. And the two lines in particular that the state of New York sued Monsanto under was, one line was called "safer than table salt," and the other one was "practically non-toxic." Okay. And those were the two advertisements they used throughout the state of New York. And so, I mean, and they stopped doing that in New York. I'm sorry.
Let me do another story on this in the future. Thank you for joining me, Robin Greenwald. Coming up, we'll speak with the attorney who represented Dr. Kevorkian about the legal state of doctor-assisted suicide. So stay tuned.
I'm Larry King, and you are watching RT America. Question more.
I'm Governor Jesse Ventura, and you're watching RT America. Question more.
You're watching an RT America special report.
Man, it ain't about him. It's about you. It's about me. It's about everybody.
Basically, everything that you think you know about civil society has broken down.
There's always going to be somebody else one step ahead of the game.
We should not be in the business of normalizing violence.
We don't need people that think like this on our planet.
This is an incredibly tense situation.
What'd you have for breakfast yesterday? Why would you pick those shoes? How fast is your Wi-Fi? What's your dog's name? Why'd you name him that? What's your biggest fear in life? Ever been on a hayride? When's the last time you read a book? What would you say if you ever met the Pope? Who's the best quarterback of all time? What's one topping that doesn't belong on a pizza? Now, I've interviewed you too. Question more.
Doctor-assisted suicide is currently legal in just 6 states, but there is a growing movement to legalize the policy nationwide. Joining me now to talk about that, the state of assisted doctor suicide, is attorney Jeff Feiger. Feiger represented Jack Kevorkian, who was convicted of second-degree murder in 1999 for giving a terminally ill patient a lethal injection. Jeff, thanks for joining me.
I should tell you, Pap, that he was acquitted 6 times when I represented him of first-degree murder.
I know,
it's only when
and
he
I was going to
represented
talk
himself.
about that. Yeah. Right, that's exactly what I was going to talk about. I say he was convicted because, as you point out, when you were representing him, he was acquitted. How were you able to get the acquittal? What is it that the jury reacted to about Jack Kevorkian?
Well, he was convicted only because when you represent yourself, you have a fool for a client, and Jack was not a good attorney for himself. But really, there was an incredible predisposition among all people in this country to believe in freedom and the right of people to make decisions at the end of their lives as to how much they have to suffer without governmental interference. And as soon as the juries believed that those decisions were being made by not Kevorkian, but by the patient themselves, and that Kevorkian was simply a doctor carrying out the patient's wishes, I was able to secure his not only his freedom but his acquittals.
Jeff, it was amazing what you had to overcome in those many acquittals that you got for him. But this poll that I want to talk about shows that 70% of Americans support doctor-assisted suicide. That's up, I think it's up about 5 points from 2012. How do you account for this growing support of doctor-assisted suicide? What is your take on it?
I think it's inevitable for a number of reasons. One is common sense. 2, you know, as much as I abhor some of the things that are happening politically in this country, there is a movement within this country to get government off your backs. That's why it's utterly confounding for me to hear that poll, 70% believe that doctors should be able to make decisions with their patients, and government should get out of it, and yet they want to end, maybe it's the same thing, they want to end Obamacare. But the fact of the matter is that people believe that government shouldn't be involved in personal decisions. Also, it's financial. How much can we sustain as a society, Pap, the costs regarding death? The last 15 days of a person's life account for over 80%, maybe 85% of Medicare and Medicaid funds. In other words, an incredible majority of the funds are being spent not to cure anyone, but just to prolong life by a couple days or weeks. Society can't withstand that. So those 2 things go into those 3 things: freedom, the right of people to make their own decisions, and money are going into that.
Jeff, the limitations that I see is, first of all, the person has to be, I think, by way of 2 doctors, have to confirm that they're less than 6 months away from inevitable death. These are general ideas, and that they have the right to go buy the medication, to do it themselves, and in the end may choose not to do it. I mean, there's no point that when you make the choice that it has to take place. What are these limitations that you're saying, are the guidelines that you're saying? How would you add to these guidelines as far as what's happening nationally in legislation?
Well, the guidelines are sort of silly. First of all, nobody can predict whether you're going to live 6 months or 6 years. Everybody's different. That's and also the idea that doctors should give pills and then walk away from the patient. I agree with Kevorkian in that was silly. If you're going to have a doctor help you, you should make sure that when it comes time that it really gets done, because the pills walking away produce some real problems. You might not do the deed. Finally, having that choice, you got to understand, and people don't understand this, they want the choice. They don't inevitably go and do it. In fact, most of Kevorkian's patients never got the help. They just wanted to know that if they needed it at the end, they could have it. That provides an emotional solace that's far more beneficial than just about anything else. So most patients don't go through with it, but there shouldn't be restrictions on doctors being present. The 6 months is an arbitrary and capricious category, and you got to, of course, be mentally competent. And then there's the problem with children, too. You've got a real problem with children. Parents making decisions about terminally ill children. Of course, we make these decisions every day. And by the way, hospice, as a result of Kevorkian and a little what I did, right now in hospice treatment, you can get, and you couldn't before, you can get as much morphine as you want. You can push the button on the morphine, and you can overdose yourself without anybody looking crossways at you. And that's the result solely of Kevorkian.
Yeah, Jeff, let me ask you this. I'm sure doctors call you from time to time trying to find out about what they need to do decision-making. What do you recommend doctors should do in states where physician-assisted suicide is not legal if they have a terminally ill patient that wants to end their life for very, very good reasons? What would you tell them? Most doctors can give the drugs basically for pain, assuming that pain is an element of the disease, and they can refer to hospice. And good doctors, caring doctors will become involved. Scared doctors, and remember, this is all about scaring doctors to make the patient suffer. So all the states that prohibit it are really intimidating doctors, not the patients. The patients are going to try to do whatever they need to do because suffering is not a good thing. And some doctors don't like to be intimidated. Some are scared as rabbits. So they're all different. In about a minute, Jeff, tell me this. What model have we seen internationally, or nationally or internationally, that you would say is proof that this is probably a pretty good system? It's been running for years in Holland, the Dutch system. England's got a modified system. The Scandinavians have a modified system. People aren't being killed. The idea of a slippery slope doesn't exist. And frankly, it's been legal in Oregon now for over a decade. And you can see there's none of this so-called slippery slope. It's not really a problem. And it's going to happen, Pap. It is 100% going to happen because, bottom line, money. Yeah. Jeff Feiger, thank you for joining me. You are one of America's finest attorneys. The fight you started here really does matter, and it'll matter going forward. Thank you. Thanks, Pat. Questions are growing about the legality of the death penalty in Alabama after the state executed 45-year-old Ronald Burt Smith last month. Not only did Smith reportedly cough for 13 minutes during his half-hour execution, but there are constitutional questions about whether he should have even been executed in the first place. Joining me now to discuss this case is journalist Molly Vygotsky. Molly, why is Alabama unique when it comes to the death penalty?
Well, Mike, Alabama is the only state in America where a judge has the power to override a jury's recommendation. If an Alabama jury says a defendant should serve a sentence of life without parole, the judge is allowed to throw out that recommendation and impose a sentence of death. And that's exactly what happened in the case of Ronald Smith. He was convicted in 1995 for killing a convenience store clerk during a robbery. 7 out of 12 jurors recommended that he get life without parole, but the judge dismissed their recommendation, and instead he chose to impose the death penalty.
Talk about the mind-baffling drama that played out in the Supreme Court right before Smith's death. What happened there?
Yeah, that was an interesting situation. Smith's attorneys petitioned the U.S. Supreme Court to stop his execution, asking them to consider if the judge should have even been able to give him a death sentence considering the jury's recommendation. And their appeal was based in part on a ruling that justices had made earlier this year in Florida, which had a similar sentencing structure. The U.S. Supreme Court ruled Florida law gave judges too much power, citing the Sixth Amendment, which requires a jury and not a judge to find each fact necessary to impose a death sentence. But justices deadlocked in Smith's case, and they refused to stay. Now, in a separate appeal to the Alabama federal court, Smith had also asked to be executed with an untried one-dose lethal injection method. He was concerned that the state's current 3-dose method wouldn't sedate him enough during the process, based on reports of that happening to other death row inmates. Well, he didn't win that appeal either, and by witness accounts, he moved and coughed when those drugs were administered, and an autopsy is now underway to determine if he died humanely.
In other words, Molly, if I hear you right, this is a prisoner who set out to find out, let me take a choice. I've looked at some of these other horrible deaths by way of other means. Suffering has been incredible, so I choose A. I choose to go with solution A. And that's what he researched, and he decided that. Did I get that right?
Correct, yes, and he wasn't alone. He's one of a handful of inmates that have been petitioning for that same thing in Alabama based on other methods that have been used, the 3-dose method that has been used to execute inmates in states across the country, and similar accounts of what happened to him, to Smith, when he was executed, happened to them. They were moving, they were coughing, there was some indication that they might have still been conscious, and of course that goes against the death penalty, which is supposed to be humane and pain-free, and once they're died, how are you going to ask them if they suffered any pain? So that's exactly why he did not want that 3-dose method. And now there are, of course, no indications that Alabama is even going to reconsider how they do the process of the death penalty anymore. There are no indications that it will change, even though a number of lawsuits are pending. Smith's attorneys had also appealed to the Alabama Supreme Court, asking them to declare the state's death penalty law unconstitutional and reinstate the jury's verdict for Smith of life without parole. But Alabama justices denied their petition, ruled the state's law is constitutional. And in fact, Alabama's Attorney General says judges are better to make that decision.
Molly, thank you very much. This is a story that is going to be continuing building over time. Finally tonight, Big Pharma might be in big trouble. 20 state attorney generals from across the country have come together to sue some of America's biggest drug companies for conspiring to fix generic drug prices. In particular, that suit alleges that Heritage Pharmaceuticals organized dinners and meetings with employees of competing drug companies so that they could secretly rig the system to drive up generic prices. This lawsuit is a great step forward towards cracking down on Big Pharma. But the United States is way behind the rest of the world in dealing with Big Pharma price fixing. Countries like Sweden, China, Germany, Japan have been taking Big Pharma companies to court for years for price gouging. But at least we're finally doing something. Americans have been getting nailed to the wall on drug prices for decades, and this could help lower drug costs for all of us. And that's our show. Be sure to follow us on Twitter at America's Lawyer and watch all of our episodes online at youtube.com/RTAmerica. Next week, we'll bring you more stories the corporate media won't tell you. Until then, have a great night.